I think Transpower, your team's here. All right, we'll reconvene the hearing of submissions on the proposed district plan, energy and infrastructure chapter. And today we're hearing, first of all, from Transpower. Good morning, welcome. Thanks for coming in early to accommodate our revised schedule. We developed a local rule. You don't need to wear your mask when you're talking into the microphone, because if you do, we can't really hear you. Yeah, it's real fun with glasses, isn't it? All right, so we've read the pre-circulated material, the evidence and the legal submissions. Thank you for providing that. You don't need to reread that out to us because we've already read it. But you're very welcome to highlight key points for us, and then we'll see if we have questions for you. If you do table additional written material today, then our preference is for that to be read out to us, since it'll be new and we won't have read it before. But other than that, over to you.
Push that. That sounds better. Yes. So I just wanted to, I guess, summarise those submissions for you, speak to what I thought were the main points. And then I've also had the opportunity to view some of the YouTube footage and read legal submissions that have been presented or lodged by others, and have got a few minor points on those as well, arising since the legal submissions were prepared. So Transpower submissions and further submissions sought amendments to this chapter, primarily to give effect to the National Policy Statement on Electricity Transmission. The Section 42A Officer Report recommends changes to the provisions, and there is a substantial amount of agreement between Transpower and the recommendations from the Section 42A report author. Ms. McLeod's evidence includes a table as an appendix which lists all of those areas of agreement. However, Ms. McLeod's evidence is that there is still some amendment required in order to properly give effect to the National Policy Statement, and Transpower supports the amendments which are described in her evidence, and they include provisions to enable minor upgrading, which is something that the National Policy Statement says should be enabled. So Ms. McLeod can explain, but her evidence suggests a specific policy direction and rule pathways that distinguish minor upgrading of the national grid from the development of or new national grid infrastructure. So that's the distinction in the National Policy Statement. Minor upgrading is to be enabled, whereas planning and development or substantial upgrades have a different direction in the National Policy Statement. The second topic, I guess, is that Ms. McLeod recommends amending the approach to managing activities within the national grid yard. So you will have seen that Transpower supports both a national grid yard and a subdivision corridor, with rules which relate to each of those, regulating the activities that take place within those corridors. So Ms. McLeod is recommending that the approach to managing activities within the yard, which is the more narrow corridor, is amended to address potential effects identified in the evidence of Ms. Titus, who you'll also have an opportunity to hear from. So those activities are earthworks and structures primarily, which we're seeking additional regulation of. And then lastly, the final point is some suggestions around simplifying the way the national grid is managed in overlays and special areas. I have to say this is not the first time this issue has come up for district plans prepared in accordance with the national planning standards. It does present a particular challenge. So Ms. McLeod has some suggestions about how to simplify the provisions so that minor upgrading of infrastructure already located in those areas, these special areas, is permitted, and that the consenting pathway for new or the development of new network utilities is simplified so that those matters can be considered on a case-by-case basis. So that's a sort of short summary of what's in the legal submissions. Turning to the matters which have arisen since the submissions were lodged. Firstly, I've had the opportunity to read the legal submissions for Kāinga Ora, and Kāinga Ora in their legal submissions agrees with the Section 42A report recommendation to not accept Orion's submission. So Kāinga Ora's legal submissions don't actually address Transpower, but they do address the national policy statement for electricity transmission, and that's why I just wanted to briefly comment on them. So Transpower has no position on the relief sought by Orion, doesn't have a view on that, but it does note that the national policy statement for electricity transmission, it doesn't relate to Orion's assets. And I watched the screening of yesterday's hearing, and I understood Ms. Appleyard for Orion to also confirm that. So it doesn't relate to the sorry, it only relates to the national grid. It doesn't relate to Orion's assets. And I understand Orion is not relying on the national policy statement for its buffer corridor provisions. Second, Transpower disagrees with Kāinga Ora that the national policy statement is limited to avoidance of reverse sensitivity effects. So you'll hear from Ms. McLeod about this, and it's also extensively addressed in the evidence, particularly of Ms. Titus, that the effects we're concerned about are not just reverse sensitivity effects, but direct effects. So the effects of other people's activities on national grid infrastructure. And policy 10 of the national policy statement isn't just concerned, this is the national policy statement for electricity transmission. Policy 10 isn't just concerned with reverse sensitivity effects, it also requires councils to ensure that operation, maintenance, upgrading and development of electricity transmission network is not compromised. So both direct effects and reverse sensitivity effects have the potential to compromise the national grid. Second point is that policy 11 of the national policy statement isn't just concerned with reverse sensitivity effects either. Sensitive activities are not just those which cause reverse sensitivity effects. So activities could be sensitive to transmission because, for example, a milking shed has a lot of structures and materials within them which can transmit electricity in the event of a fault. So that would be a sensitive activity, but it might not be one which causes reverse sensitivity effects. And lastly, in my legal submissions, I drew attention to the fact that Transpower and Hort New Zealand were discussing the use of the term produce packing, and Hort New Zealand's suggestion that it should be replaced with post-harvest facilities, and Ms. Wolf's evidence provided a suggested definition for that term. Now, Transpower doesn't oppose the amendments suggested by Hort NZ, but it is actually continuing discussions with Hort NZ about whether that really is the best definition, or if we can't come up with another one, which is more certain and easier to implement in the district plan, focuses more on the intensiveness and scale of the activity, and is drafted in a way which is easier for council officers to apply. So what we'd like to suggest is that these discussions continue, and if we're able to provide you with an agreed position in the next week or two, then we send that through to you, or at a time, if you would prefer to set a deadline for that, then we'd be happy to work in accordance with that. So those were the only comments I wish to make. I'm happy to take any questions on my legal submissions.
Yeah, thank you very much for that. Yeah, we understand that Transpower is privileged to have its own national policy statement, and that refers to the transmission network, whereas Orion has a distribution network, which is different, and therefore the MPS doesn't apply to their network. And thank you for telling us that you're having ongoing discussions with Hort New Zealand. That's helpful. Our approach is that within 10 working days of a hearing concluding, we receive a reply report from the officers where they address evidence raised during the hearing and tell us if they've changed their mind on anything. So if you're able to conclude those discussions with Hort New Zealand and provide some written material regarding the outcome by next Friday. And that will give the officers time to consider that and roll that into their advice to us in their reply report. So if that could be achieved, that would be great.
Thank you. I don't think there'll be any difficulty.
You've got something on the
Yes,
floor.
I have dropped something off my jacket.
And so thank you. Now just see if we have any questions arising from the legal submissions. Andrew, any questions?
Thank you, Mr. Chairman. Yeah, I do have one. So your clause 5.2, in particular B, 5.20 B, you talk about in there the management requirement policy 10 sets a high bar. The test is not whether the council would like to manage activities or even whether it's reasonably practicable. I'm just interested in that statement and also the council's requirement in section 32 to, I guess, consider efficiency and effectiveness and other reasonably practical options. And do you have any comment on reconciling what you said there with the section 32 requirements of the council? I mean, as someone who drafts provisions as well, I'm acutely aware of other methods to also achieve the same outcome and whether it has to be a district plan or a bylaw or something else. I'm just interested in your thoughts on that.
That's an interesting question. I don't think I've been asked this before, but you're right. I don't think that actually the two directions conflict. The council's direction is to give effect to the national policy statement. There's a variety of ways in which it could do that. Transpower's providing submissions as to what it thinks is the best way to do that. But councils all around the country have come to slightly different conclusions based on the particular circumstances of their district or region. And so it might be that there are some options that can be considered, and some of those will be more or less efficient and effective. And that can be considered under a section 32 analysis.
Okay, all right, thank you. Oh, no, thank you, that's fine.
Okay, thank you. Thank you. So the first witness for Transpower is Ms. Nisa Titus, who's an electrical engineer. Now, you said you don't want summaries read out, so I've asked her to just speak to the main points of her evidence, and she has some notes to help her do that. She hasn't presented evidence at a council hearing before, but I've promised her that it's not such a scary experience.
That's good. And if you've prepared some speaking notes, which is good, if you're just intending to read those out, that's fine. And if you do that, we always appreciate a copy of those speaking notes being made available to us via our hearing secretary, which you can just email to her later.
Thank you.
Okay.
Good morning, Chair and Commissioners. My name is Nisa Titus, and I'm a transmission line engineer at Transpower. I'll proceed to summarize the key points from my engineering evidence that was submitted and then comment on submissions by other parties. The national grid is a perpetuating asset that requires ongoing maintenance, operation, development, and upgrade. My evidence highlights that a regulated national corridor is essential for unrestricted access to the national grid at all times to deliver a secure and reliable electricity supply. Physical access to transmission lines is required for all routine maintenance and project work, as well as any emergency work that is required to restore supply to the grid. Sensitive activities such as schools and hospitals should be avoided beneath transmission lines due to the electrical risk, as well as annoyance caused by transmission lines and the challenges presented to Transpower when access is required for maintenance and project work. Direct effects like earthworks and underbuild in the national grid corridor need to be managed to avoid safety risks and restricted access. NZECP 34 compliant earthworks can still compromise safe electrical clearances, support structure foundations, and access, as demonstrated in the examples and pictures provided in my evidence. Transpower operates its assets as safely as possible, but there are electrical risks due to high voltages being carried on the network. Electrical risks like earth potential rise around transmission structures and substations can be managed by regulating land use and development in those areas, as in the case of Arthur's Pass substation. The national grid is enduring critical infrastructure, both locally and nationally. It is essential that there is a planning framework in place that will enable operation, development, and asset maintenance to occur efficiently and unhindered. I wish to respond to two matters arising since engineering submissions were filed. The first is in relation to the submission made by Chorus, Spark, and Vodafone regarding limiting reflectivity of structures to 37%. Transpower agrees with the submission as we're not able to comply with the requirement. Transmission line structures are galvanized with a protective zinc coating to prevent rust and maintain the service life and quality of the steel. A newly galvanized transmission support structure has a reflectivity of over 70%, which fades with time and exposure to natural elements. If required, there are ways of reducing the reflectivity, with the most common methods being painting and grid blasting. However, this is not in the interest of our assets, as it reduces the service life and quality of our assets. Currently, Transpower does not do any reflectivity testing on our existing asset, mainly because it's never been reported as a problem. If we did need to do testing, we probably would have to send samples to the lab in the absence of having the right equipment to measure the reflectivity. My understanding is transmission structures have a smaller reflective surface in comparison to mirrored buildings, for example, where reflectivity would be considered to be more severe. Perhaps it's not necessary for the reflectivity standard to apply to network utilities like transmission lines. My second comment is in relation to question from the panel around whether landowners should be aware of NZECP 34 and its requirements. From an engineering perspective, I would like to confirm that it is important for landowners to be aware of NZECP 34, and in particular, the electrical safe distances for excavation, construction near overhead line supports, electrical safe distances between conductors and buildings, electrical safe distances for the operation of mobile plant near conductors. The landowners need to be aware of these requirements if they're wanting to develop or extend new buildings, subdivide or perform earthworks near transmission line assets. Interactions with landowners and developers have indicated that some are not aware of NZECP 34, nor fully understand the requirements that need to be adhered to. Recently, I had interactions with a landowner wanting to develop new buildings adjacent to one of Transpower's line. In our discussions with him, it was apparent that he was not aware of NZECP 34 and the specific electrical safe distances that need to be adhered to. Transpower then worked with the landowner to make them aware of the requirements and incorporate them into the building designs accordingly. In this instance, the designs were in early enough stage and were able to be modified to make them NZECP 34 compliant and avoid direct effects on the transmission line. I'm now open to answer any questions from the panel.
Great, thank you very much. Any questions?
Thanks for your submission, your evidence. It was very thorough, and it's actually quite interesting to have that understanding of, you know, we see the wires around everywhere, but actually the effects they can have on surrounds. So thank you.
No, but I also like to thank you for your evidence. I found it extremely helpful, and pictures are great to give context and extra explanation. So thank you. Appreciate it.
I've just got, just like to ask you about the points you make about the Arthur's Pass substation and this very helpful diagram that I think you included. Now, so is that that's a state highway? Yeah. And then we've got the railway line. Is Transpower aware of any intentions from either Kiwi Rail or NZTA to actually do any works within the rail corridor or the state highway corridor regarding putting in new wires or
Not
anything?
currently.
No, okay. All right. If they do intend to do some works, is it normal that they would contact Transpower first and discuss what they wanted to do with you?
So Kiwi Rail and NZTA are considered as informed parties. So they do know the risks, especially with regards to EPR. So
Yeah.
they would consult Transpower with any works that they plan to do in that area.
All right, thanks very much. Thank you very much for that, and I endorse the comments from my colleagues. Your evidence was very interesting and illuminating, particularly the images, which are also always very useful. And if this is your first hearing, you've done a good job. I'll just make one comment, just try and talk a little bit slower when you read out your material to us. But other than that, no further questions. Thank you.
Thank you. I have to say for my part, I find figure 18 on page 31 particularly illuminating. So this is a figure which shows ECP 34 compliant earthworks. But clearly ECP 34 doesn't allow for access for maintenance and other activities unless you can get up a ladder. Yeah, yeah. So the next witness for Transpower is Ms. McLeod.
Good morning. Before I answer questions, I just would like to very quickly highlight some key matters addressed in my evidence and also respond to some matters raised in the evidence of other witnesses. I've read the addendum, section 42A report and the response to questions to the hearings panel, along with the evidence of others where it's relevant to the relief sought by Transpower. Perhaps my first point, though, I should note that my opinion is aligned with the conclusions of the Section 42A report in respect of a significant number of matters. In my evidence, I've set those out in attachment B for succinctness, but also it is a demonstration of how much agreement there is. I acknowledge that the Section 42A addendum addresses a further amendment or correction that was identified in my evidence as well. If we turn now to objective EI03, I note that you've asked a question in respect of whether incompatible activities and reverse sensitivity are different things. In my opinion, reverse sensitivity is a subset of incompatible activities. That is, I see it really simply that where a reverse sensitivity effect arises, this is inevitably because there's a degree of incompatibility between two activities. In response to the Section 42, in response, the Section 42A officer suggested that policy EIP6 be renamed incompatible activities as opposed to reverse sensitivity. And I just note in my evidence that I've similarly identified that the titling of policy EIP6, reverse sensitivity, does not encompass the matters addressed in that policy. And I suggested an alternative renaming being the effects on important infrastructure. You've heard a lot about minor upgrading, and you've asked some questions in respect to minor upgrading and the merits of including a definition in the district plan. My evidence confirms, firstly, that the MPSCT requires decision makers to enable the minor upgrading of the national grid, and I consider that to be quite a positive obligation on decision makers. My evidence goes on to conclude that a definition is not necessary, certainly in the context of policy EIP1. It's my view that permitted activity standards have the effect of serving almost as a proxy for a definition where what is minor is really differentiated by the permitted activity standards and what might be permitted by the district plan. And that allows the plan writer, in effect, to establish the thresholds for what's acceptable as minor upgrading in the context of Selwyn. I highlight for you as well that the NES for electricity transmission activities can be understood in a similar way. And in fact, if you were to ask me, what do I think is minor upgrading from a national grid perspective, that my go-to would be what is permitted by the NES for minor, what's permitted activity under the NES, and what are the thresholds that might trigger a consent under those regulations. I've observed that Ms. Foote is going to provide you with a possible definition, and if helpful, I could do a similar thing based on the NES, with the caveat, of course, that there are possibly other witnesses that you should hear from, for instance, Mr. McCarrison and Horn in relation to telecommunications or Waka Kotahi in terms of roading. Now, still with minor upgrading, I note that Ms. Wharf for Hawke New Zealand has expressed some concern about the increase in voltage of lines having an impact on landowners or land occupiers. In my evidence, I address this, but I don't understand it to be the case. It's my understanding that if a voltage of a line is increased, the line operator necessarily has to do the work to ensure that NZECP 34 is complied with, and that might be raising conductors or retensioning the conductors to make sure that ground to conductor clearances are adhered to, and importantly, that electric and magnetic fields still continue to meet the relevant standards. With that work done, there is no impact on activities occurring at on the ground or around those structures. And any effects on possible future uses is a separate and not really an RMA matter. It's addressed through compensation and a test of injurious affection that really goes well beyond what the RMA is required to deal with. Again, in my evidence, I note that increasing voltage of existing transmission lines is a permitted activity in the NES. Staying perhaps on the theme of NZECP 34 that you've heard a lot about, you had questions yesterday for witnesses and also of Ms. Barker in respect of NZECP 34. In my view, the district plan is not being used as a mechanism to achieve compliance with those regulations through duplicating those regulations. Rather, the ECP 34 is a tool used in the plan by mirroring similar requirements to give effect to the NPSCT. Now, this is particularly important for the rule framework as amended by my evidence, where the rules are effectively drafted to lean on NZECP 34 to establish thresholds and provide for certain activities to be permitted in the national grid yard where they can achieve compliance with NZECP 34. If NZECP 34 were not applied to, for instance, rule EIR2, then that rule would need to be rewritten to apply some other way to manage structures under the conductor's midspan. Effectively, what I'm saying is the rule needs to also achieve compliance with NZECP 34 to allow for the establishment of appropriate activities midspan. If you don't apply ECP 34, then there'll need to be some other rule that says either no structures are allowed midspan or only structures that are 1 metre high or something unusual like that. And probably through the years of working with implementing the NPS, applying the thresholds in NZECP 34 quite directly has proven to be straightforward, easy to justify and test from a 32 perspective, I guess. And also it has more appeal to stakeholders. And I'm aware that Transpower have worked for years with stakeholders like federated farmers to determine rules. And obviously you can see the nuanced approach to types of agricultural activities that can occur mid-span is really a reflection of that. So yeah, from a Section 32 perspective and your need that you've indicated to possibly undertake a re-evaluation under Section 32AA, it's my view that using NZECP 34 as a tool to achieve the relevant statutory outcomes or objectives, including giving effect to the policy 10 of the NPS, is the most appropriate way to achieve those. NZECP 34 establishes practical thresholds for activities that can and cannot. So it's both sides, if you like, can occur mid-span or also near the foundations of structures. It's an efficient and effective way to establish the appropriateness of activities when compared to other options, which would likely include more stringent rules. So for you, I think the choice isn't between NZECP 34 or nothing, it's NZECP 34 or some other provisions to achieve policy 10. Turning now to activity status and cultivation, this has been raised by Ms. Worf in her evidence for Hort New Zealand. She suggested that the rule proposed in Transpower's submission and as supported by me in my evidence, she's noted that NZECP 34 includes an exemption for normal agricultural cultivation. And she thought that the same exclusion be included in any rule that regulates earthworks in the national grid yard. I agree with her that normal agricultural cultivation should not trigger the need for a resource consent in the national grid yard, but I don't think that the rule proposed does that. And the reason for that is really simple, and that's that the National Planning Standards earthworks definition excludes cultivation. So any rule for earthworks would naturally also exclude cultivation. Turning to Rule EIR2 about structures in the National Grid Yard, I just want to briefly highlight a key amendment supported in my evidence. And that is Transpower submissions seek that the rule only permit a limited range of structures in the national grid yard. That is permitted activities in network utilities, non-intensive, non-inhabited agricultural structures that also meet the requirements of NZECP 34. As notified, the rule didn't achieve this, and it's not clear whether this was intentional or it's just that the national grid rules can sometimes be a bit cumbersome. My evidence concludes that to give effect to policy 10, the rule needs to be amended to better achieve that outcome, and I've set that out in the attachment A to my evidence. Back to Ms. Wharf again, she suggests in rule EIR2 that there need to be a further matter included, and that's a reference to clause 2.4.1 of NZECP 34 in respect to crop protection structures being near national grid structures. And she notes that often rules for the national grid will include this provision as well, and I've agreed with that, and I have an amendment that I propose, not to EIR2 but to EI rule requirement 2, and we can provide you with a copy of, oh, you've got it already? There you go. And that effectively should address Ms. Wolf's concerns, noting that she also promotes a restructure where the rule requirements will be brought into the rules themselves. Perhaps I won't deal with produce packing versus what was post-harvest facilities, yes, but note that those discussions will continue. And just as a final matter, I wish to perhaps foreshadow an issue you'll hear more about in later hearings, and that is the way in which the effects of significant infrastructure, in particular the national grid, are managed in overlays or special areas. A number of witnesses have highlighted issues with how significant infrastructure is managed in those overlays, and all have offered different solutions to you. And that perhaps illustrates the complexity of the challenge of how to manage special infrastructure with special areas as well. In my evidence, I note that alongside the need to recognise and provide for the development of the national grid in the NPS, there's also particular and somewhat nuanced directions in respect of how the national grid is managed in those overlays and special areas. These directions really do set the national grid apart from other activities. And in my experience, this usually means that the district plan will need to similarly set apart the national grid and include specific provisions to correctly give effect to the NPS. The Selwyn district plan does not currently do this, and in my evidence I note that the same level of regulation appears to apply to the national grid and overlays as would apply to any other activity. In my evidence I propose amendments to give effect to the NPS, but I would like to signal today that, given the shared view of witnesses in respect of the issues, but not in respect of the solution, there may be some merit in reconsidering approaches prior to future hearings in respect of those and where those hearings come up for those overlay topics, so that there's a more considered approach or a consideration of the pathways that may be available for significant infrastructure and the national grid.
Just in terms of that last point, we initially started with a hearing panel of 10 people. That's being split now as we move into the other topics. One stream of hearing panels will be chaired by myself, another stream will be chaired by another commissioner. So in terms of the issue you just raised, then you're probably best to address that directly to the council officers rather than to us as a hearing panel, and particularly the officers who might be preparing future Section 42A reports.
Yes, yes. I guess I'm just signalling that there's an issue that everyone's identified. No one's come up with a succinct or straightforward solution. And if there is an opportunity to work with the officers prior to getting to those special area hearings, I think it would be really helpful.
Yeah, I'm not disputing that. I'm just saying we're not the right audience.
No. With the exception of the matters that are before you today, I understand.
Yeah.
Yeah.
Sorry, so is there any more?
No, that's all. That's all.
All right, I'll see if we have any questions for you. Andrew, we'll start at your end of the table. Thanks.
Thank you for your evidence. Appreciate that. Yeah, I think it was touched on before. I'd be interested if you are able to provide a definition of minor upgrading. Whether that, if you could, that would be helpful, I think. And also, would you be happy if that minor upgrading was limited to Transpower's assets only or to network utilities more generally, so that could be more targeted? So consider that as well, please.
Certainly.
Thank you. You paragraph 70 of your evidence, you introduce an amendment to clause 6 of EIP2, and particularly the addition of where appropriate at the end, and you provide some rationale for why you support that. And it's a question I've asked as well of others. If this policy was an encouraged policy, would that be a suitable alternative? So where a substantial upgrade of important infrastructure is undertaken, encourage reduction of adverse effects where an upgrade is undertaken. Would that be equally acceptable to you, as opposed to the term or words where appropriate?
Yes, certainly. The words were appropriate are more similar to the policy in the MPS, but the point of my evidence is there needs to be a pathway for situations where the reduction of effects isn't the best outcome for the national grid, or in fact appropriate. Yeah.
Okay. Thank you. Just keep going. So paragraph 81, clause B, 81B. And I understand what you're saying. I'm just interested, are you aware of any examples where, I guess, lay people, submitters, neighbours have produced information off the internet and provided that and supported justification?
Yes. I have had direct experience where I've been involved in hearings for Transpower, where any number of submitters have produced material from the internet in relation to electric and magnetic fields, and that's the reason for seeking as much clarity as possible.
Sure, thank you. So paragraph 112, and it's the proposed amendments to EIR2, Rule 2.
Paragraph 12?
112. 112, proposed amendments to EIR2.
Yes.
So, one of the witnesses yesterday for Orion recommended that the clauses Roman numeral 1 to 6 are all deleted. And I'm just interested in your view. So I assume that Transpower does not think this is necessary for their assets.
No.
Okay. Thank you. I guess further to that, so if those clauses were removed, consent was required, would it be onerous for Transpower to respond as an affected party on all those matters where all structures required consent, even though it wasn't of interest to you?
Perhaps the way to start answering that is to say that it's hard because there's all negatives and negatives. Transpower's worked really, really hard with stakeholders over a long time, and including through some appeals, to enable agricultural and horticultural structures, with the exception of those few listed. And the reason for that is because of their scale and intensity of use, compromising the national grid. Deleting those would enable them to occur mid-span, and that would be problematic because of the scale and intensity. Is that what you're suggesting? You're suggesting that that certain agricultural and horticultural activities should not be allowed mid-span?
I think if you exclude all those clauses, then what you're saying is establishment of new expansion of existing structures. And the wording in the Ryan was also they swapped the wording around so that you could
Yeah,
use any structure
yeah.
under it at all. And I'm just interested
Yeah,
in whether that's
so-
unnecessary, basically.
Transpower's view is that certain agricultural and horticultural structures are okay mid-span, subject to complying also with ECP 34, with the exception of those. That's Transpower's position. I understand Orion might have a different position, which
Sure.
is a more clean corridor, but without wanting to speak for Orion, their asset is different and their conductors are lower, so that the chance of even getting, say, for instance, a hay barn mid-span would be less likely.
Yes, sure. Thank you. For
Yeah.
clarifying
Does that help?
that. It does. Thank you. And that was my final question. Thank you.
Thank you.
Thanks for your evidence. It's quite thorough as well. And you've introduced some new rules. And are these rules ones that you've had implemented in other plans?
Yes, yes.
okay.
And certainly both the neighbouring Huranui and Christchurch plans include rules that are similar. They're not the same because the format of plans is different, but the extent of regulation is almost identical.
Okay, and that's to implement your environmental standards and
Yes.
those others. Thank you.
Turn on my microphone. Paragraph 57. Just wondering if you could further explain why you think we need to refer to minor upgrading in clause 1, given that clause 2 of E1P1 already talks about upgrades.
What I'm trying to achieve by that amendment is to have the enable apply to minor upgrading and the recognise and provide deal with upgrading other than minor, which better reflects the distinction in the MPSCT.
So minor upgrades are a subset of upgrades.
Yes.
And clause 2 already provides for upgrades and therefore by default provides for minor upgrades, which is stronger than enabling, isn't it?
I had always considered that enabling something was stronger than recognising and providing for.
It doesn't say recognise.
Yeah.
Clause
No,
2
it
says
doesn't.
providing
No, you're
for.
right. It doesn't.
So is providing for stronger than enabling?
No,
Why?
because you could provide for something by a discretionary activity or a non-complying. You're still providing for it in a way.
Does not enabling have the same meaning?
My understanding had been, with reference to the MPSCT, that the enablement, the clauses that are enabling are more permissive than the recognise and provides. Whether I'm right or wrong, I'll leave that to you.
All right. Maybe if you could address that in reply, just the difference between the words enable and provide and actually why they've been used differently in that clause 1 and clause 2. Okay. Paragraph 70. And just in relation to clause 6 of E1P2, which my colleague addressed you on, I'm just trying to understand the actual concern there. Clause 6 doesn't require the reduction of adverse effects upon a substantial upgrade. It's not a directive policy. It merely says that it should be used as an opportunity to reduce. Now, using an upgrade as an opportunity to reduce, in my view, is different than a provision that would say using substantial upgrades to reduce. It's different, isn't it? There's a nuance there. So
Yes, there
what's the
is.
concern?
My concern is that policy 6 of the MPSET and the drafters of that national policy statement included both the use as an opportunity, that nuance, plus the where appropriate as well. And the reason for my amendment was to closely align that clause 6 with policy 6 of the MPSET.
Okay, so, right.
And having understood some of the scenarios where the reduction of effects as part of a major upgrade may not be possible.
Right. So you're basically just wanting us to parrot the MPS.
Well, it does closely reflect it, but I did accept in a question earlier that it could be achieved another way.
Yeah.
And I I would be comfortable with the suggestion that Mr. Willis made.
Yeah. No, I'm just trying to understand the concern. So the concern is that it does not reflect the wording in the MPS. Is that your concern? Or
I think the national policy statement wording is it needs to be taken quite seriously, and there's a reason that where appropriate's there. But I do appreciate that it's nuanced and that the use as an opportunity is a lot gentler than a compulsion.
yeah. Okay. All right. So maybe in the reply report, if you could just turn your mind to that as well. I mean, given what the MPS already says in its policy 6, I kind of wonder why we need clause 6 at all in a district plan, but it's there, so never mind. We need to figure out what it's going to say. Your paragraph 77. I just want to understand before you get into the italics, like the wording, you say that the note should be further amended to ensure direction also encompasses notices of requirement for designations. And then the italics would say, suggesting crossing out the word resource consents. So it wouldn't refer to resource consents or designations, but my understanding of a designation is that it's designed to override the provisions in a district plan, and that's the benefit of a designation. And I assume most contemporary designations sought by Transpower would have conditions that would override and supersede provisions in the district plan that apply to the land within the designation. So 2 issues. One, just trying to understand the concern, given that you have a notice of requirement ability, or Transpower does. And then secondly, how does deleting the words assessing an application for resource consent assist with the outcome you're seeking anyway, which is that those provisions would apply to notices of requirement? There's kind of 2 parts here. I'm struggling to understand.
It would probably be beneficial to Transpower for those provisions to not apply. But the reason, firstly, a designation overrides rules, but it doesn't override the objectives and policies. And when determining or making a recommendation, as the council would do on a notice of requirement, the considerations under section 171 of the Act include a consideration of the relevant objectives and policies. So they kick in that respect. They also perhaps more subtly would kick in when a council was considering an outline plan. And as any other relevant matters, for instance, if you had a substation, say in Arthur's Pass, that might have some significant natural values, then those policies might be elements that the council officers would give consideration to in recommending changes to an outline plan.
Okay.
So that's the first part of your question, I think.
Yeah.
The second part is whether the deletion here
Yeah.
is of any assistance at all.
Yeah.
And I think there are many ways you could skin the cat with that. You could talk about when implementing the district plan instead of when assessing a resource consent. You could say when assessing a resource consent or notice of requirement, or there would be other expressions that would similarly capture the scenario I'm speaking of.
Can you just remind me where that note is in the provisions?
The note to plan users.
Yeah, where does that sit?
Is it immediately ahead of the rules? Yes, it's under the heading for the rules.
Okay, I see. So it's clause 4 of that note. Yeah. Okay. All right. No, thanks for clarifying that. Paragraph 97. I just want to ask you about your recommended inclusion of this clause 3. So a decision maker would be required to read the plan as a whole. So I'm struggling to understand why it's not suitable to have a policy E1P6 refer to important infrastructure generically, and then for the subsequent provisions in the rules to single out the national grid where appropriate. So I'm failing to see the rationale for including clause 3.
Yes, the reason for including clause 3 is because clauses 1 and 2 don't make reference to managing sensitive activities.
But the part of that policy does. Review sensitivity effects, or is this something different?
Policy 11 of the National Policy Statement refers to the identification of a buffer corridor within which sensitive activities will not be provided for in plans. So the purpose of clause 3, whether it's expressed as well as it could be, is to particularly address sensitive activities, a defined term, and the relationship to the buffer corridor, which I think is different to the not compromise or the obstructing of access. In my view, when I was looking at this policy, and particularly considering how it gave effect to policies 10 and 11 of the National Policy Statement, I thought there was a gap in relation to those sensitive activities, and that was the reason for including clause 3. It doesn't need to be expressed in precisely that way, but that was the purpose of the amendment.
Okay. I'm always interested when submitters suggest adding provisions whether or not it's actually necessary. So that's hence the number of the questions. Just wanted to ask finally, my final set of questions, I think, are about your paragraph 122. And it's suggested new rule E1RX, which I found particularly confusing.
I'm sorry.
So the title of the rule is fence posts.
Yes.
But the rule is much wider than fence posts, isn't it?
Yes,
Yeah, okay. Now, clauses A, B, and C, do they mirror NZECP 34?
yes.
And so, just to help me understand the rule, so a post hole for a fence, is it allowed to be 300 millimetres deep?
You could have the post hole for a fence to 300 millimetres,
Right.
but any deeper than that,
So that's that.
yes.
So that's not very good for a fence post.
No,
is it?
it's not. No.
All right. So, okay, that's not very practical then. Does clause A conflict with clause C2? And clause A talks about a line tower or a pole,
Mhm.
and clause C2 talks about a line, pole or stay wire.
Mhm.
So they're different.
They are different, and the clause C says clause A and B do not apply to the situations in clause C2. And clause C2 effectively provides for a little bit more of a hole in situations where there's a pole as opposed to a full lattice tower type foundation structure.
But because clause A doesn't mention a stay wire, it wouldn't apply to a stay wire anyway, would it? So you don't need to exempt it because it's not covered.
Possibly. And I think this is the interesting thing about how hard or easy NZECP 34 is to understand, because when you ask me that question, I would I answer possibly because I want to go back and test what ECP 34 says.
Yeah. Yeah, okay.
So just to add to that, a lattice tower, you wouldn't need a stay wire.
No.
So a guy wire would just be for a pole. In fact, yeah.
Yeah, okay.
Yeah, or possibly a pie pole, I think. Mm.
Now, clause C2 contains a number of exceptions, which mirrors 2.2.4 of NZECP 34, except for agricultural cultivation. Is there a reason why you didn't also exempt agricultural cultivation?
Because there's no need to, because the definition of earthworks excludes cultivation.
This rule covers earthworks and the disturbance of land. Okay, for fence posts only.
Yeah. The reason for
Just a minute, but that wouldn't be abundantly clear just upon a reading of the rule, would it?
there would be no harm in including a note to say cultivation is excluded from this rule because it is in any case.
Or just adding it as a C, Romans 3.
No problem at all.
Yeah.
That would be fine.
So when I read this rule and got really confused by it,
Yeah.
I just wondered to myself whether it would be better just to permit the activities that ECP 34 2.2.4 allows within the grid, and to permit fence post holes of a certain dimension, and then to make other earthworks within the national grid yard or maybe a restricted discretionary activity or something. I just wondered if there's a simpler way of achieving the outcomes you're seeking to achieve here.
Look, I'd be really happy to have another attempt at drafting that. If you're confused, plan users will be confused, and that's not a good outcome.
Yeah.
Yeah, I'd be very happy to have another attempt at doing that.
Yep.
And in terms of default activity status, as the rules refined, I can give that some thought too, noting that where an activity wouldn't be allowed under ECP 34, there's no point in it being a restricted discretionary activity.
Anyway.
But if there's the ability for Transpower to give some consideration as an affected party and a consent could be granted for an activity, then I think a restricted discretionary activity would be appropriate.
Yeah. Okay, that'd be helpful. So then, yeah, if you could consider some drafting that perhaps doesn't
Certainly,
confuse
yeah.
me as much.
Yeah.
And and I'd be more than happy for you to liaise with council officers and that I mean,
Sure.
I'm sure they'd be happy to work through this with you as well. I
Yes.
don't know if they found this rule confusing as well, but
Yes, I see a nod.
I'm sure my colleagues found it confusing. They just didn't want to admit
Yeah.
that to you. I reckon.
I'm sorry.
All right, well, that's the end of my questions, but thank you very much for your evidence and for the extra material that you've provided and for your commitment to do some little bit of homework for us
No problem
within
at
the
all.
next week.
Thank you for your time.
Thanks.
Thank you. So those are, that's all for Transpower, and we'll get that information in by the end of next week.
Yeah, that's lovely. Thanks very much. And we do appreciate the importance of the Transpower transmission network. So our questions aren't intended to indicate that we don't understand that importance. We just want to understand what you're asking for and the reasons for it, and to have provisions that hopefully we and other users of the plan can eventually understand.
We'd like that too.
Yeah.
Thank you.
Thanks. So we'll just take a 5-minute break now while we set up the Zoom call with Lynette Moore from Hort New Zealand.
Yeah, I was just talking, where I grew up as a child was near high tension lines. So it was actually quite interesting reading all this stuff as well, like in that context as well, because you actually, living around in Wilson now, you don't even have the wires in the street. You know, you don't see them. Yeah. Yeah, yeah. We're gonna watch. Yes.
Right, we'll reconvene the hearing. So Ms. Wolf, can you hear us? We can't hear you. It's like that ad on TV when Gandalf's talking to us. Have you seen that ad where he's using his crystal ball to talk? He says, I think you're on mute. I think I'm on mute. Even there's a little cross by the speaker symbol there on the bottom. Do you see on the right hand of that toolbar? Is that the problem? Just undo that. So, Ms. Wolf, can you say something?
Oh, right. I can hear you. Can you hear me now?
Yes, we can. We've
Ah.
resolved the technology issue.
Sorry about that.
That was just a little glitch at our end. So, thank you.
Oh, I'm not very savvy with Zoom, so I was getting worried. It doesn't work when I've got my computer on the docking station. So.
Right. Well, first of all, we trust that your husband's medical procedure has been successful.
Yes, he's doubled his heart rate in the last week, so that's something.
Okay. And thanks very much for accommodating a movement in the schedule in terms of your presentation and coming in over Zoom. So good morning and welcome. We've read the submission from Hort New Zealand and we've read the evidence that you provided. So thank you very much for that. As with previous hearings, you don't need to read that out loud to us, but you're very welcome to highlight key points or matters that have arisen during the hearing if you've managed to watch it on YouTube or wherever it's available. And then we'll see if we have questions for you, but over to you.
Thank you. And thank you for the opportunity to present today and accommodating my time restraints. Just to note that Appendix 2 to my evidence sets out a table, and there are many matters that I've agreed with the Section 42A report. So I haven't addressed those in my evidence and won't address them now, but just acknowledge the consideration that the report writer has given. Perhaps just to start, just to set a bit of context, Hort New Zealand's interest in infrastructure is really twofold. Growers need infrastructure to be able to operate, and they also host infrastructure on their private property and can be impacted by the presence, and particularly when infrastructure providers seek limitations on activities because of their infrastructure. So essentially the grower is paying for a public benefit. So in the planning context, what I've been trying to do through my evidence is balance the interests of the infrastructure provider without unreasonably impinging on a grower being able to undertake their activities on their private land. This is particularly relevant in Selwyn, where there's a large area of highly productive land that's being used to produce food for the well-being of people. And that's an important consideration. So we don't want to limit the ability to produce food. And I note that in the response to the questions from the panel regarding important infrastructure, the 42A report says, therefore, established important infrastructure and its continued safe and efficient operation and security does intentionally take precedence over proposed incompatible activities. So the debate at the hearing essentially comes down to, well, what are those incompatible activities? And to what extent should activities be limited to enable the precedence of infrastructure? And is that the appropriate approach? So being able to undertake cultivation of a paddock under lines or irrigation or support structures to enable crops to grow, buildings on site to support the food production, being able to plant trees within 13 kilometres of an airport without an onerous bird management plans are all activities that should be able to coexist with infrastructure without unreasonably impinging on a grower to undertake their business. And we do note that infrastructure providers are looking for security through the district plan, but there are other mechanisms that can be used, such as easements, that can provide a level of security, but that rather than district plan provisions. And fundamentally, what's really, really important is the relationship between the landowner and the infrastructure provider. And this is something that the district plan can't provide for, but it's an essential part of the package. And you've had questions about NZECP. And my response is that it's really part of the responsibility of infrastructure provider to engage with the affected landowners and provide such information. And Transpower have a network of landowner liaison officers around the country whose role it is to engage with landowners and talk about such things as NZECP. And recently, Transpower's engaged with New Zealand and kiwi fruit industry to develop a guide to growing under the lines, which was referred to in the evidence of Ms McClung in hearing 1. So it's these types of initiatives outside the district plan that are also an important part of achieving the objectives in the plan. I will say much has been made of giving effect to policy 10 of the NPSET. There are 5 words which seem somewhat glossed over: to the extent reasonably possible. Policy 10 is not absolute, and this is where we want to reflect this in the policy framework. So really it's about balancing the range of competing interests about what's reasonable for all parties. And for that, I've sought changes in my evidence to Objective 1, Objective 3 and Policy 6, and also sought changes to the rules for structures in National Grid Yard, and I acknowledge the acceptance by Transpower of one of those regarding clause 2.4.1 of NZECP. In response to matters raised, in terms of the definition of post-harvest facility, small-scale packing sheds have been provided in multiple plan provisions for activities in the National Grid Yard. What I have sought is a similar approach in Selwyn. Produce packing has not been listed in the exclusions and other plans except for Christchurch, and we note that there was no right of appeal on this. So essentially this inclusion of produce packing is a new discussion with Transpower. What is anticipated is there's a small grower who has a shed on their property which they're using for sorting and packing produce prior to distribution, can have it under the National Grid Yard, in the National Grid Yard, if it meets the clearances in NZECP and is set 12 metres back from the structure. These types of sheds are included as ancillary buildings to primary production and are very different in scale to the large scale post-harvest facilities that generally source products from multiple growers. And it's agreed that such large structures should not be permitted in the National Grid Yard, but smaller structures could well be provided for. In response to my evidence and the submission I put up, and in the proposed definition for post-harvest facility, Transpower contacted Hort New Zealand because they didn't like the definition of post-harvest facility because it could be one grower with a very large packing shed post-harvest facility. So we've looked at different options, and one is to amend the rule by adding a limitation produce packing within the rule, or to define produce packing, or to define post-harvest facility. And at this stage, there hasn't been any resolution with Transpower as the most appropriate. I noticed in terms of the earthworks provisions that are sought in Ms. McLeod's evidence and the questions around the cultivation, and she's correct in that the earthworks definition and the planning standards specifically excludes cultivation, but because it's particularly referred to in the NZECP, we've got different documents treating cultivation differently. So maybe it needs to be specifically included so it's clear that cultivation is included if you decide to have a rule for earthworks as Transpower is seeking. I also note that the setbacks that Ms McLeod is seeking are different to NZECP 2.2.1 because in fact there's a setback of 1 point, sorry, I just need to get it to be very clear. The setback in NZECP is no greater than 300 millimetres when 2.2 metres from the pole will stay, not the 12 metres, or when it is at a greater depth than 750 between 2.2 and 5 metres of the pole. So what Hort New Zealand was seeking, that if there are earthworks provisions, they are as in NZECP. And I acknowledge that the change I sought in paragraph 1712 of my evidence, Ms McLeod, is now accepted. The other change that I sought was moving REQ2 to Rule 2 because I saw it as being more than setbacks of the structures. It was a whole suite of provisions about what's appropriate for artificial crop protection structures. And in my view, that's part of the rule around structures in the National Grid Yard rather than as a separate requirement. And requirement 2 will only apply to Rule 2. So you wonder why it can't all be neatly put together into the rule. In terms of other submitters, Bird Strike, I supported the Section 42A report conclusions in terms of bird strike and the provisions sought by Christchurch Airport. And I listened to evidence yesterday. There's still some questions I've got regarding, and it's still not really clear exactly what they're wanting, particularly within the 8 to 13 kilometre area. There are growers in this area. It's an area where there's highly productive soil. And growers do use mitigation methods because they don't want birds either. So they use nets or scarers and to get rid of birds as well. The issue of availability of water is, I think, somewhat of a distraction because growers or landowners currently have consents for water takes can change the nature of activity. So a dairy farm could convert to an orchard or plant some crop. I feel that at the moment there's a lack of information on this issue, particularly relating to these fruit tree crops, which weren't considered in the Christchurch plan hearing process. So at this point in time, I have seen nothing further in the evidence of the airport to change my view that the limitations sought by the airport are not appropriate within the 8 to 13 kilometre distance. In terms of Orion, they acknowledge that the most affected landowners are in the rural area, and they seek to better understand horticultural structures that the Hort New Zealand seeks. But we've had Horticulture New Zealand's had no approach from Orion to seek information or develop a set of provisions. And I note particularly that the Islington to Springston line used to be part of the national grid. So I'm wondering why, in fact, the provisions are seeking are actually more stringent than what are applying to the national grid. And in my opinion, the distances set out in NZECP 34 are appropriate. In terms of the discussion about minor upgrade and the issue of voltage, and I've heard Ms McLeod or Transvaal this morning talk about if there's an increase, they will lift in voltage, they'll lift poles, etc., to ensure that there's distance. That's fine, but we want to make sure that that is the case. So it's an increase in voltage that will not increase the landowner requirements for clearance distances, so that the onus is on the operator, not the landowner, who then has an increase in voltage over their property and they've got to make the adjustments. The adjustment should be on the part of the operator. And in terms of minor upgrading, I think in a definition could be appropriate, and happy to engage with others in that discussion or provide you with examples from other plans. So those are my initial comments. Happy to take questions.
Thanks very much for that. And Andrew, we'll start at your end of the table, please.
Thanks, Mr. Chairman. Thank you for your evidence. I think I've got about 2, 3, 4 questions. So just paragraph 5.26.
All right, let me just get
5.26.
Yes.
And it's just your reference to dairy processing plants. And
yes.
I'm just interested in it. Are there specific issues that you could point us to that would result from them being included in important infrastructure, or is your concern more sort of philosophical or theoretical about having them included as important infrastructure?
I haven't seen anything that that justifies that they should be included in important infrastructure, and it was this creep of what was important infrastructure. And my question was, well, do they really need it if they've got the protection of a specific zone?
Okay, but sure. Thank you for that. So paragraph 13.8.
Yes.
So for clarity, are you saying that NZECP can be relied upon and therefore rules not needed in the district plan?
Yes.
So other submitters have suggested to us that NZECP is not well known or understood by landowners. Do you have a comment on that?
Well, as I said earlier, that this is where the responsibility comes for these operators, and this is what's happened elsewhere in the country, is that the operators are engaged with their landowners and made them aware of NZECP. And they are government regulations. That's the status of the document. And there's also the hazards from tree regulations, which we haven't talked about here, but that also growers need to comply with. And there are growers who've had to take rows of trees out because they don't comply with the tree regs. So, and the point of these distances is that they do provide for the safe functioning of the electricity network, and other distribution companies around the country are relying on NZECP, not other specific corridor provisions.
Sure. So what you're saying is that you've said it's a responsibility of the infrastructure providers, but are you saying that your members are well aware of these requirements, or they're not well aware of these requirements, or only where they've been contacted by the
become
providers?
Increasingly more aware of them as the debate has occurred over the last 10 years around the national grid.
Okay, thank you.
And certainly like the initiative with the developing the guide with Transpower certainly talks about NZECP and, you know, so there's increasingly information going to growers around their responsibilities under the regs.
Okay, thank you. So your paragraph 13.10, 13.10. And you've talked about there should be provision for some structures within the 10 metres either side of the significant electricity distribution line similar to the National Grid yard. Do you have a list of structures or what should be provided? Has Hort NZ been working with Orion to come up with things that might be appropriate in that setback?
No, there's been no engagement recently with Orion during the development of the plan at the pre-notification. There was some discussions, but they weren't very fruitful. And it resulted in the provisions as they've been notified. So that, but you know, if Orion want to engage with Hort New Zealand and discuss what might be appropriate, I'm sure that would be welcomed.
So just for getting a bit more clarity then, so you're saying similar to the National Grid yard, so all those matters are already included in that rule. And in addition to that, stockyards and crop support structures, artificial crop protection structures that meet the requirements of NZECP. Those are the matters.
Yes.
Okay, thank you.
So a farmer could build a farm shed under the line if it met NZECP, and as Mr. McLeod said, those lines can be somewhat lower, so the ability to do that may be somewhat reduced compared to the National Grid. But there is at present no provision to be able to do that. They just want a clear corridor.
Yep, sure.
And stockyards, for instance, there should be adequate clearance. And the problem that you've got, well, I'm not advocating for federated farmers, but stockyards are often near the roadside where the lines go down.
Sure. So my final question in relation to bird strike and in paragraph 21.2.
Yep.
And I guess what I explored yesterday with the airport company whether at the moment there's a requirement for certain, well, a proposed requirement for activities defined, I think 4 or 5 defined activities needing to have a bird strike management plan in order to be a permitted activity. That wasn't provided in the evidence of Mr. Bonus. And I queried them as to whether they would accept simply just evidence that the landowner has made the airport company aware of the proposals, the land use activity proposals, and also had an agreement around allowing them access to monitor bird life as a result of those activities. Do you have a comment on whether that would be acceptable to Hort New Zealand as an alternative approach to what the airport is seeking for their bird strike management rules?
Yes, I think it comes back again to that landowner liaison that, you know, the airport needs to engage with the landowners. Certainly the management plan, I think you identified or someone identified as being fairly onerous. And so as I understand it, and I was rather confused by the evidence, the moment the only regulated activity they're seeking in that 8 to 13 kilometres is the landfill, and therefore the other activities would be on a monitoring type approach. And if that's the case and the airport's prepared to engage with the landowners in a positive way, I see that as being a good alternative.
Okay, thank you. No further questions.
Nicole? No? Vicky? So Ms. Worth, just 2 matters, or 1 matter really for you. Just at your 11.13, and it's the request to roll in E1-REQ2 into rule E1-R2.
Yes.
Just kind of want to understand that a bit better. And you refer to the national planning standards, but E1-REQ2 is included in rule 1-R2 by cross-reference, isn't it? Because it's
Yes, but what I'm saying is it's more than just a setback, and therefore it would be better that the rule providing for those structures was in the rule rather than in a separate. So a grower could go to the rule and they would know what was provided for without having to do an unnecessary cross-reference to a requirement that only relates to that rule. Where the requirements become useful is where the same requirement applies to a number of rules within the plan. But in this case, the requirement only applies to one rule.
Yeah, I'm just still struggling to understand. I mean, because it's an e-plan, you just need to click on the hyperlink and it takes you straight to it. So it is included by cross-reference, and the hyperlink makes it really easy. So, I mean,
That's assuming everyone uses e-plan.
Well, that's the only way the plan's going to be available.
I'm happy to. I didn't actually put it up. Do the inclusion, and I'm happy to do the inclusion and provide it so it's clearer to you how it would look if it was included in rule 2.
No, there's no need for you to do that. I'm just struggling to understand the merits of the request, given that it's an e-plan and there's a hyperlink to it. So, and it's already included by cross-reference. That's all. Okay, so not a question for you, but to the officers, can you make sure, if you weren't already going to, can you specifically address the issues that Ms. Wolf raises in her paragraphs 13.9 and 13.10? And that's all I had. Thanks very much for coming in to our hearing by Zoom.
Well, thank you.
Right.
Right.
That's the end of House hearing from submitters today. So the next step in the process is for the officers to prepare a reply report for us. And our rule of thumb deadline is 10 working days from now. So hopefully you'll be able to achieve that. So to assist you with that process, in terms of what we've asked you to address throughout the hearing, is there anything that you want to clarify with us where you think they've asked me to do something, but I'm not quite sure what they want?
No, I'm clear on what's required.
Good on that?
Yep.
All right. Well, thanks very much for that. And that adjourns the hearing for today. Thank you.